All right, good afternoon, everybody. Thank you very much for being here at Case Western Reserve Law School for our Sugarman Lecture featuring Phil Hackney. And in a few minutes, you'll hear all about him, and then you'll get the wonderful presentation that he is going to provide. I am Michael Scharf, the co-dean of the law school. Jessica Berg, our other co-dean, is at an event we're having in New York, and so we are doing what co-deans do, which is divide and conquer. I do want to start off by recognizing one of our faculty members who've been very involved in this, and that's Matt Rossman there. So thank you, Matt. And I would like to introduce Paul Feinberg, who was a partner of Norm Sugarman at Baker Hostetler. And Paul is now senior counsel at the Jewish Federation of Cleveland, and he teaches nonprofit organization law here, and he is going to do the introduction today. Thank you, everybody, and welcome to the law school.
Thank you all for coming. First, let me tell you a little bit about Norman Sugarman. He's a distinguished graduate of the law school and also of the college. He was the first non-political appointee to a IRS assistant commissioner position. This is back in the 50s. And this was a tribute to his intellectual and technical skills. He was an extremely talented and creative tax lawyer with an almost encyclopedic knowledge of the Internal Revenue Code. He was scary sometimes. But moreover, he was a super educator. And he gave speeches all over the country to professional groups, tax seminars, ABA meetings. He had a marvelous ability to present complex topics in simple, understandable terms. It was a rare talent. So after his death, a memorial fund was established and funded by his partners at Baker Hostetler, his clients, Jewish Federation of Cleveland, and others. And part of this money was given to establish this lecture because it thought that this lecture was the best way to honor his memory by continuing his teaching efforts. We also endowed annual or semi-annual, biannual forum at the City Club on philanthropy in America, and that forum is next Friday. So that's the background on the Sugarman Lecture. So let me introduce today's speaker, Professor Philip Hackney of the Louisiana State University Law Center. In the program, his bio is laid out, so I'm not going to really repeat all that. But what I want to point out is that he had extensive experience in the Office of the IRS General Counsel. And this gave him an excellent understanding of the workings of the IRS, an overview. He had direct experience in doing litigation. He had direct experience in working on complex regulations. So the main point I wanted to get across is that he's well qualified to speak on today's topic, which is improving IRS charity oversight, responsible congressional delegation, responsive IRS rulemaking. And it appears now that this is an extremely timely topic in view of all the noise that we're hearing about regulations and how we have to get rid of them. But we in the tax bar, particularly in the exempt organization area, depend very much on the guidance that the IRS gives us. So regulations are not necessarily a negative in our world. In fact, there are sometimes complaints that there are not enough of them, that the IRS has been remiss in not issuing enough guidance. But unfortunately, cuts to the IRS budget and so on have damaged that process. So I'm looking forward, as I hope you are too, to hear what Phil has to say about rulemaking. Thank you.
Thank you, Paul, for being involved in this series. I want to thank Case Western Reserve for making this possible, and thank Deans Scharf and Berg for giving this facility to make this possible as well. I think the Jewish Federation, Paul, is involved in part of the funders, as well as Baker Hostetler. I work in the charity community in law schools and so on, so I always like making certain to thank the various parties that make this kind of thing possible. It's really important. So, thank you all for being here today. Paul talked to me about Norman Sugarman, and he sounds like somebody I would have very much enjoyed working under, and I hope I can rise up to a level of excellence that I hear that he demanded and the type of attorney he was. I expect that I would have very much enjoyed meeting him. My motivation for the talk today is I care a lot about both the nonprofit charitable community, but also the IRS. And I think both are sort of under some bit of attack. Whether you're seeing things regarding charities, whether it's Red Cross and its activities within the charitable community, or you have veterans charities that are being abused in various ways, it seems questionable whether there's enough regulation, enough oversight over this community right now. And then on the IRS hand, there's question whether the IRS has the people to do the things it needs to do. And there's even some question from some whether the IRS should continue to be the place where oversight is done over charitable organizations. So I'm going to be talking about that. I worked with Chief Counsel for about 5 years. Had I been there about 3 more months, the IRS Tea Party scandal, controversy, however you want to call it, depending on your political persuasion, you come with different perspectives of it, would have been sitting in my lap. And so finding ways for the IRS not to find itself in that position again has been a strong motivation for me. So I want to try and think about that today. The IRS division oversees charitable organizations has been under attack from sort of a couple different angles. A large segment of the American society believes the IRS targeted conservative groups trying to obtain tax exemption. Starting around 2011, these organizations, the Tea Party groups, were filing in order to further conservative causes. And there's a belief by a lot of folks that the IRS actively went after them as unelected bureaucrats because they didn't like what they were doing. That's one area of attack, and they'd like to see the IRS significantly circumscribed and held back. But there's another that think that IRS does not and cannot do enough to guidance and enforcement to regulate the nonprofit sector, and then we need to look for other means of regulating charities. And I'll talk to the state level of that as well. Although I think many conflate these two problems together, whether the IRS is not doing enough or the IRS was problematic in the Tea Party area, I think they're coming from two different perspectives. It's two strains of thought. Those worried about the idea of targeting likely view agencies as populated by unelected bureaucrats who are out to enforce whatever political position those bureaucrats prefer, rather than as agents looking to enforce the rule of law. I think that's the sort of the Tea Party folks out there. Those who want better regulation of the nonprofit sector are more likely to view agencies as having a positive, democratically based role to fill in our representative democracy. So you've got two different folks, but they're both pushing on the IRS in terms of its role, and so I want to think about how to deal with that aspect. The most extreme critics argue the IRS division in the area should be significantly hobbled. Others suggest that the function of overseeing charitable organizations should be taken out of the IRS and put into some other body. Kristen Hickman from an administrative law perspective actually thinks that this group is one that should be cordoned off in a sense. Lloyd Mayer, though, kind of thinking about it from a charitable oversight perspective, has said that there's just not enough that can be done to oversee charities from this group, and it should be done in a different group. I argue that we should be conservative and look for ways to improve the system from within. So I think this role should stay within the IRS, and I want to think about how the form of the law can be changed modestly to bring about more consistency and deal with the fact that the IRS doesn't have the resources it really needs to ideally oversee this group. The problem is created in large part, I think, because we're unwilling to dedicate the resources that we need to oversee charitable organizations. And I'll get into some of the numbers regarding the size of the sector and how much enforcement resources that we put towards them, but it really comes up short when you look at it. I think, and one of the reasons that I think we should keep it within the IRS is because I don't think we will put more resources. I don't think we as society are willing to put the resources towards regulation of the charitable sector. At least we're not there yet. So I think you have to think of ways of doing it with the resources that you have. Secondly, removing the function from the IRS, and this is probably my most important concern, would be highly likely to create blind spots for the IRS. I think that part of the IRS role, in order to be a good tax collector, it has to see the whole economic picture. And if you start taking pieces out of it, that creates problems down the road for enforcement. So although there are a number of options to consider to improve IRS oversight, such as penalties, you could come up with different penalty regimes or audit choice, I focus instead on how to design the form of the law and who should design that form. It calls for Congress to delegate to the IRS most of the detailed rulemaking function and for the IRS and Treasury Department to actively engage in making new rules to give advice. As Paul had indicated, there is a strong sense that the IRS has kind of been pushing that to the side and not doing those things, and I think that's correct. While standards rather than rules might be more ideal in regulating the sector, and I'll discuss this today, the great number of unsophisticated parties trying to both comply with the law, so we've got the charitable sector, probably 80% of that charitable sector out there is unsophisticated parties. Additionally, the low number of enforcers and the unsophisticated nature of those individuals suggest that we should move towards rules, a much more rule-based regime. This will have some problems, and I'll discuss that, but I think it's the only potential. I'm also hint at some of the challenges raised by this approach from administrative perspectives. If the Treasury Department, rather than Congress, is engaged in this activity, it raises issues of delegation and democratic control and so on. And if the IRS is using the form of law that I'd like to see used here, which is lower levels of guidance, it also raises issues of force of law. And whether that would be an effective means is sort of the question. In thinking about the question of what good IRS oversight would look like, the identification, I think, of the problem is important. I've argued that one locus of the problem is the vague standards Congress provides to the IRS to enforce. Because many unsophisticated individuals are trying to comply with the law on behalf of charities, and the IRS does not have sufficient resources to carry out its role, the standards are a problem. It, I think, led to some of the problems that the IRS faced in the Tea Party situation. They were trying to enforce a very vague standard regarding political activities of, these didn't happen to be charities, but it's close enough, and you're facing some of the problems, that it was too costly for the IRS to come up with a quick way of disposing of this stuff, and it created its problem. Such a circumstance, I think, demands more rules to aid in both compliance and enforcement. The problem also is in the non-transparent manner in which the IRS seems to choose organizations for audit. This leads, I think, to the sense of the folks from the Tea Party side of thinking that somebody's out to get them because they don't know what the rules are, and the IRS seems to come after them. So that lack of clarity, that standard aspect of charitable enforcement, charitable law is a problem. So finally, on the matter of rules and standards, while Congress should generally enact standards here, I think they should enact rules in certain cases. I think that given the lack of resources that there are, it would be very helpful if the IRS Congress significantly cut down the number of organizations that fall within the ambit of the IRS. So in the 1980s, for instance, Congress decided to take insurance out of the tax-exempt sector, and I think that's the type of move they need to look for now. So Blue Cross Blue Shield used to be a charitable organization, tax-exempt organization, no longer is because of 501M. I think Congress could think very seriously about taking organizations like hospitals out of that area because it creates significant challenges for that group to deal with. All right, so the problem. Much writing suggests that something is amiss with the IRS oversight of the charitable sector. Lloyd Mayer, Mark Owens, and many others have found significant problems. There's inconsistencies at times, not enough guidance coming out of this group, and it's not doing the job that it needs to do. This premise, though, assumes that the primary role of the IRS in its tax jurisdiction over charities is to ensure that these organizations are well run. I think there's a question about that. A lot of the folks that are complaining regarding the IRS function thinks that the IRS should be in the business of regulating charities at a federal level. I think their primary function really is as part of the revenue collection, and it just happens that they get brought into that ambit through tax exemption. Congress has enacted many rules that carry out that kind of role where the IRS has become, in effect, a regulator of the sector. Excess benefit transactions, if any of you are familiar with that, is in the nature of that. But I think it has to do with some other things, in revenue collection in particular. Although there had been critiques in the past after the IRS Tea Party controversy, the scrutiny has increased sevenfold, I'd say, in terms of folks worrying about this group. There had long been frustration regarding the role of oversight of charitable organizations. I don't know, does anybody know how many are enforcing here in Ohio? How many in the Attorney General's office? Paul? Generally, at the state level, Attorney Generals are enforcing charitable organization law. There's usually one person. Ohio probably has a few more given the size of state it is and the charitable groups that are here in town. I saw information the other day. I think there are close to 400 full-time equivalent employees overseeing the charitable sector at the state level. And when you think about the size of that sector, and I have some numbers on that, it's just not close. Now, if you add the IRS, you probably get another 400 people that are looking over the charitable sector. What is the size of the sector right now? There's about assets and revenues have almost tripled from 1995 to 2014. Assets grew from 1.1 trillion in 1995 to 3.2 trillion in 2013. So it's a sizable group. About 10% of salaries in our economy come out of the nonprofit sector generally. So it's not a small group, and you've got maybe 800 people that are sort of enforcing this law. There's not many other opportunities either to enforce that law. Donors, for instance, rarely are able to bring any kind of case against a charitable organization's operation. So there are real concerns regarding its operation. Many had thought that when the Congress enacted the income tax in 1913, a new potential regulator had arrived. That wasn't likely, they weren't likely a big player until probably around 1969. Paul has told me he basically got his career out of that. In 1969, Congress enacted an enormous regime regarding charitable organizations, and that still kind of controls today. And it created a new player, and lots of folks have often had high hopes that IRS would be that place that would improve that sector and be the place where oversight could take place. But it doesn't seem to have taken hold. Now, it's really hard to say whether it is a problem. There is not a lot of good, strong evidence across the board that we have wildly non-compliant charitable organizations that are violating norms. It is mostly through anecdotal evidence in newspapers and so on. I think there needs to be a lot more work regarding whether charitable organizations, some real empirical work regarding whether charitable organizations are a problem and not following these rules. Brian Golly recently did some stuff on private foundations and found they seem to be relatively compliant groups, but it's just not clear. But senators have problems. Senator Grassley has begun a crusade about 10 to 12 years ago, going after universities, going after hospitals, worried that largely that charitable dollars were not going to real charitable needs. Universities were not making the kind of payouts, so they were trying to get embarrass Yale and Harvard to pay more towards students. So Grassley sees problems, and other groups do as well. Additionally, Treasury Inspector General in 2013 found that the IRS itself just was failing in its role, particularly in the Tea Party area. It had picked organizations for scrutiny in improper ways, the Treasury Inspector General thought. It found many questions the IRS were asked were improper, and that the length of delays that these organizations were being put through were not okay. And I'll be honest, in working with that organization, I think that's right. And I think it's a broader criticism of the IRS generally, is that they don't have the people to do the job that they're being asked to do. I mean, I regularly sat there worried that I had a time bomb on my hand as I dealt with the different cases that would come. I'd be worried about the one case that's not being dealt with, and it happened after I left, not because I left, but it happened. So to summarize, there have long been concerns that there is no strong regulator of the charitable sector, and that this fact causes harm. Many have given up on the states to fulfill this role and had put their trust in the IRS instead, but the IRS isn't doing it. The IRS has not been fulfilling that role. The Tea Party highlights the real problems that can result from the IRS trying to fill that role while lacking the resources to carry it out. In at least two different things that it's trying to do. It's trying to be revenue collector, but it's also trying to be regulator of the sector. And this creates problems with the situation. It has significant trouble getting the law right in a timely manner, and can appear because of that to be biased. That was certainly the picture I got while I was there in some sense, and it was clear to the conservative groups that it was a problem. I don't think that anything nefarious ever happened there. I feel confident in that sense, but the look was not good, and I can't argue against that. I think we're trying to do too much with the IRS in that function. I don't think it can play the real, the ideal charitable monitor that many want it to be. Many want it to be there overseeing these groups and ensuring that the people that get this status are good folks that are doing good things, whatever that may mean. Everybody's got this conception in their heads regarding what charitable is. It's usually wildly inconsistent with what the law might be, but they have that vision in their heads, and they think the IRS can do it. I use the metaphor of, I don't know, have you ever read The Circus McGurkus by Dr. Seuss? They have Mr. Sneelock, and he's going to do a million different things, including making 500 gallons of lemonade and all of the circus acts that are possible. And I think many people think of the IRS in that kind of Dr. Seuss, Mr. Sneelock kind of manner. He can do whatever you want him to do. And it can't. And I think we have to accept that. And part of my message is it cannot really be the ideal charitable regulator that we want, but it can be better than what it is if it begins to enact more functional, simple, clear rules that are simple yes, no type questions that put people into one box or the other. This comes with problems. The reason you use standards, and I'll talk about this a bit more, is to try and get things right. And it turns out that if you're trying to do something like charitable organizations that are based on an annual basis, you're carrying out some sort of licensing regime, and to do justice, you probably don't want rules. And I'll talk about why that is. If you have rules, you're going to have major under-inclusive and over-inclusive. But I think the problem has become so exacerbated that we're getting things, instead of precisely right by having the standards, precisely wrong. And we would be doing a whole lot better if we accepted an imperfect system that got things more consistently right, rather than getting things all over the place and putting out a picture that doesn't help the IRS at all, that puts the IRS mission of being a revenue collector in jeopardy. And I think it has been in real jeopardy as a result of that. Whether fairly or not, it's there. So I want to focus on how can we make it as effective as possible under the resource constraint that exists. And this is not unusual to agencies. Agencies regularly are tasked with a job that is too much. I think if you look into VAs, the VAs are roundly being criticized, and they probably suffer significant resource constraints as well that lead to some of their problems. And if you look around agencies generally, this tends to be a problem. I think, though, we have to accept the imperfect nature of how much resources we're willing to put towards this function and work from that standpoint to get to a better spot. So just a few thoughts on rules versus standards. Many of you have probably thought about this before. To me, it's a fundamental, critical thing to think about. At their best, rules eliminate the tyranny of arbitrary acts of unelected bureaucrats against individuals they just do not like. They're more transparent. They're there. A rule is, to put it on the table, if we're driving along and we have a speed limit sign that says no going over 55 miles an hour, we have a clear rule. We know before we act whether we're going to violate that rule or not. If we say no driving at an unsafe speed, now we've got a standard, and you won't know before you act whether you violate that thing or not. And I think we have to move more towards the speed limit sign to the extent we can than towards the no driving at an unsafe speed. But rules are costly to enact. They're not well fitted to all circumstances. They often miss their mark at a name of justice. A standard arguably allows us to come much closer to justice than does the rule. The standard provides flexibility to an adjudicator to achieve justice. And it's costly to develop these things. In a sense, we need all of the information before we act on this rule. And it's difficult to find that out regarding charitable status. It forces us to think about what those things are. Rules in such an environment can quickly become anachronistic and no longer useful to what we wanted to do. And I'll refer to those, and I'm sure you know it, over-inclusive and under-inclusive. We can pass a rule that essentially brings certain charitable organizations into the fold that otherwise we would not. In the area of politics, right now we have the Johnson Amendment that many have talked about today that prohibits organizations from intervening in a political campaign. If we make that into a rule in the way FEC does, it's going to be fairly easy to avoid that thing. And you'll probably have some organizations that maybe under the justice of the rule would not fit. Additionally, you'll have some that should have fit and don't fit. It does not connect the rationale for the rule to the rule itself in many instances. But they tend to be more transparent, and so we have to think about weighing the two. Professor Kaplow developed a helpful way to think about when to enact rules and when to enact standards. It's the question in his mind, and I think this is right, is should the information be gathered and processed before or after the individuals act? And it's a question of whether it's more costly to implement a rule at the legislative stage or after the fact. And most of the time we've accepted that in the charitable area, it's easier to enact it after the fact rather than before. Where a law, though, will apply to many repeated acts, rule is generally preferable. So if you're talking about laws regarding sanctioning particular activity, having very specific rules that are going to apply to a bunch of situations are very helpful. Where a law will only apply to a few acts, obviously a standard's more preferable because you don't spend money ex ante before this thing happens. And there can be a continuous of these things. We can have a simple rule and a complex standard, and we might compare those two things against one another. We can have a complex rule that has its own problems and a simple standard, and each of those can create their own problems. How do you pick when you're going to do it? You have to look at the number of acts that are involved, the type of acts, the type of information you need to you want to use, and you also want to look at who the parties are that are under this thing. Is it a lot of money involved? Are the parties sophisticated, unsophisticated? If you've got unsophisticated parties, there's a lot of reason to believe they're never going to obey those rules to begin with if it's a standard where it's costly for them to find that information out. So to the extent you have that. And then finally, if you have an enforcement context where you don't have a lot of people that are applying, enforcing the area, you can get into a situation where rules are more useful. So what does charitable tax law look like? It provides that corporations and trusts that are organized and operated exclusively for a charitable purpose are considered exempt from taxation. And the standard is extremely vague. The IRS even has regulations defining things like education. Anybody familiar with Big Mama Rag? In Big Mama Rag, the DC Circuit Court of Appeals found the IRS regulations, not the statute, the regulations that the IRS used regarding the definition of education to be vague. So it suggests something about the statute itself had to have been vague itself if the regulation enforcing it was a problem. Why do we have this thing here? Rationales for why we provide federal benefits to charitable organizations could be helpful in identifying what we're trying to do in it. The rationales include that we're trying to subsidize public good things. There's never been great content to that, but we have charitable trust law that identifies those things that are good for the public interest, in the interest of social welfare. It could be that we've got it there to regulate the charitable sector, and some have made that claim. And finally, it might even enhance pluralism. And in Regan versus Taxation with Representation, one of the justices discussed that aspect of the charitable sector and nonprofits generally. If the purpose is to reward those activities that bring about public benefits, the IRS needs some way of determining that. If the purpose is to regulate the charitable sector, the focus of the law might be much more on the behavior of leaders of charitable organizations. It's not entirely clear. And because it's not entirely clear, it's really hard for us to come up with what those rules are going to be. By defining those, we could get into a better spot. There might even be a fourth, and I kind of suggested this at the beginning. It's really to pull in every bit of economic activity within the IRS's vision so that we know what all organizations are doing, so there's less likely to be tax sheltering activity. It tends to be really hard to figure out what groups are charitable. I don't know if any of you have sat down and tried to figure out. Matt has been telling me some of the different groups that his clinic is doing right now. And if you sit down with a group of folks and try and figure out whether an organization is charitable or not, I guarantee you everybody in this room will come to different opinions on the different types of questions that get raised within this sector. It tends to be something that changes with time. Bob Jones University, for instance, when the Income Tax Act was enacted in 1913, it was legitimate to discriminate on the basis of race. So when Congress enacted the Income Tax Act and created tax-exempt organizations, it was certainly okay. But later on, Congress approved an IRS decision that Bob Jones, who was discriminating on the basis of race, on the basis of prohibiting interracial dating, that now was not possible. And so charity and charitable law, what we want to affect, changes with time. And when you have something that changes with time, you generally want standards. Additionally, we're trying to apply this to a huge slice of life. it's difficult to figure out how to apply rules in that environment. But the challenges of running this system are too great. There are a lot of organizations that must demonstrate compliance with charitable tax-exempt status annually. There's over 1.2 million organizations that are registered currently. The IRS data, probably not complete because there's lots of churches out there as well, another 400,000 or so out there. Additionally, the IRS gets about 70,000 applications per year, and it has maybe 200 employees that make those determinations. It has to come up with systems to deal with that fact. And as I mentioned, the other factor to consider here is that the sophistication of the parties complying is rather low in most instances. The money at stake often is relatively low, although in some cases you have major hospitals and universities where that money is very high. It's from National Taxpayer Advocate and continuing cuts to the IRS, it's pretty clear that the IRS does not have the people it needs to do the things it needs to do. So, ideally, I would say that IRS, that the law regarding charitable organizations under tax-exempt status would be in the form of a standard. And we would have lots of employees there ready to make those kinds of calls. But the reality of the matter is that we don't put the resources towards it that we need, and so we have to come up with more rules. The limitation of the IRS enforcement resources and protecting the IRS is too significant, in my opinion, to continue down a path where we expect this organization to operate as this ideal regulator that we have a vision in our head regarding. And I think we need to dumb down our concept about what we can accomplish within the IRS. And I think that will get us closer to something that is consistent on a regular basis. The recommendation is not likely to be supported strongly by those who think the IRS should be the national regulator of charitable organizations. Most of those folks have moved on to suggesting get it out of the IRS and have another organization do this activity. I'm not opposed to that. I think there is some need for such an organization, but I don't have strong hopes that we're actually going to dedicate the resources in some other agency as well. We have not done that so far, and so we have no reason to believe that's going to happen in the future. So I think it's time to consider how to dumb down, in a sense, what the IRS rules are regarding this area. Additionally, such a move would importantly help protect the IRS against charges of acting politically, because the rules and decisions would be more transparent than is currently the case. The IRS should make no mistake that this is a panacea against such charges, but only protection. Part of the disagreements that I think you see in the IRS administration of this area have to do with a disagreement on what the law is. So in the Tea Party case, I think a lot of those folks think that it's against the First Amendment to prohibit their right to speak. They believe their church groups, their political groups should be able to speak. And so I think when they are attacking the IRS, I think the message that's behind that is a frustration with the rule that Congress enacted, that the IRS is trying to carry out. So even if they enact rules, I think they should prepare to be attacked. And so it becomes important to have those in place to try and protect them as much as they can. Assuming they continue to disagree with the rules on the front, they're likely to find trouble with the IRS enforcing the rules, such as the Johnson Amendment. Finally, it's important to consider the positions of those who favor a strong national regulator of charitable organizations. Many now argue that this function should be pulled out entirely. I really think this is a mistake. I think it will create significant blind spot in IRS revenue oversight. I believe that a large part of the function of the law regarding nonprofit organizations is to ensure the IRS has the best vision, as I said. Maintaining that function within the IRS then is important for that reason. The final part I'll discuss here is that how should they develop the rules? In a perfect world with sufficient resources, we might prefer standards, but if we need rules, how we're going to do it. I think the Treasury Department should be engaged in that activity, and I think they should be engaged in it at as most efficient ways as they can. The revenue rulings and revenue procedures are not typically done pursuant to notice and comment, and this creates some problems for force of law concerns. Courts have been mixed in terms of whether to give deference to revenue rulings or not. Occasionally, the IRS has won in those areas and gotten deference. Most of the time, though, the IRS takes the position that these revenue rulings do not have the force of law. They are not essentially legislative regulations. They're not done pursuant to notice and comment, so they should get the deference afforded to them there. I think mostly the IRS should put that to the side and deal with the fact that they have organizations that they have to enforce on now. Those groups will be better off if the IRS gets out rules quicker and faster. And they'll be more protected with those things there. I'd like to do some more thought in terms of what type of deference courts should provide in those areas, and I haven't pursued that as much, but that's where I'd like to take some of this work next, is what level of engagement with the public should the IRS do to develop these rules? And then, depending on how they do that, what level of deference should they give in this area? I do think that Congress should strongly consider, though, pulling more charitable organizations out of the mix. People have long argued that organizations like hospitals are not a good fit within the charitable sector. Depending on the rationale you come at from, if you're looking at a Henry Hansman sort of efficiency analysis, it's not clear that hospitals need to be in that place. The reason, though, I think is important for why organizations seek this status, and I think we need to begin thinking creatively about divorcing some benefits that come with tax exemption. So currently, in order to get the ability to issue tax-exempt bonds, organizations like hospitals want to get tax-exempt status to get there. I think we ought to consider taking them out of tax exemption and allowing tax-exempt bonds perhaps to be issued out of hospitals outside of that context. Additionally, hospitals, one of the major things that they want tax exemption from is that states give them property tax exemption. The number one amount that I understand from hospitals that they count upon on a regular basis, they know they have guaranteed money that they save by not having to pay those states. If that gets decoupled, you deal with that as well. States need to figure out their own rules instead of attaching it onto the IRS. I think there are a number of places where the IRS could look to issue useful rules, particularly in the area of excess benefit transactions where it is actual behavior by individuals. They could spend more time. And I think the IRS did some useful things in there, giving safe harbors for organizations that have sought out reasonable salaries. To the extent they're able to come up with more of those types of things, I think they put themselves in a better spot. Few more thoughts. Given the resource challenges faced by the IRS and its exempt organization division, the Congress needs to look to cut as many as it can. So hospitals, I think, are a good area. Other areas they might think of as well. I'd like to open the floor for, is this? Yeah. Yeah. Okay. For questions. Yeah. Yep, in the back. I don't think they were thinking about them much. I think at the time in 1913, everybody looked at these organizations as organizations you wouldn't tax anyway. And so I don't think they thought a whole lot about it. And I've done some work looking at, there is no information really as to why they put these groups into these places, or very little. Some of the stuff, you have the Chamber of Commerce saying, hey, we're doing these things that are very good for the economy, and we're just not a place where you would think to tax. Additionally, traditionally, tax-exempt organizations, the nonprofits, they're our original corporations. They date back to the founding of the country. And they were carrying out very public functions. They're turnpikes, schools, churches. Sometimes churches were even issuing taxes. So there was a sense, I think, even at that time, that these are not appropriate groups to tax. And I think they just wanted clarity. Those groups were looking for clarity, particularly the chambers of commerce, I know, went in and argued those things. Charles Eliot, I think it's Charles Eliot, argued as well earlier on that these organizations were not of the type, and I think there was not a lot of thought to that aspect. It's a good question. I've tried to give some thought to it. But. Question?
Given your concerns about the IRS's ability to regulate the charity sector, what's your thought about how bodies like Charity Navigator and GuideStar and those other private evaluators, not regulators of charities, but what's your thought about how they fit into the mix and how valuable a service they are?
Yeah, so this is a place that I'd like to think about a lot. I think if we're looking for a solution long term, I think we have to look into sources like that. What I envision, I work with a group called Louisiana Association of Nonprofit Organizations. So this is a trade organization for nonprofit organizations in the state of Louisiana. And every state's got something along this lines, and there are federal groups as well. And they relate, in a sense, to groups like GuideStar and so on. They make information available about these organizations so individuals can get public information. And the 990 works in that sense. I mean, most of the information they're getting is from the 990. A project that I think needs to be done is to figure out how you can make the 990 a more functional instrument. I don't know how many of you have reviewed the 990, but it often doesn't provide a lot of enlightening information that you'd want to know. There was actually a case recently that gave a little bit more information than the charity wanted. Richard Spencer, white nationalist, has the National Policy Institute, and his organization failed to file for 3 years and just recently lost its tax exemption. He put together 3 990s to file, 2013, 2014, 2015, and he made the mistake of including the Schedule B. The Schedule B includes donors. So a Georgia community foundation was outed as having donated part of their DAF to them. There's real issues with giving disclosure regarding donors, dating back to issues of NAACP and so on. Real good concerns regarding that type of information. But I think there could be more done in terms of getting relevant information into the public regarding these organizations. And I think those are the places to start. I think you could consider trying to implement something along the lines of American Medical Association, American Bar Association, where there is some professional association that groups get accredited within. I think we're a long ways off from getting something along those lines, but I'd like to see something move in that direction. Yep.
Speaking of the 990, you talked about rules and you talked about standards.
Yep.
What about strategic suggestions? For example, the questions on the 990, do you have a code of ethics? Do you have,
Yep.
And it was almost immediate that nonprofits started running to attorneys or someone to prepare those,
Yep.
even though there was no sanction for not having it.
Right.
On the horizon.
Yeah. So this is another area I've tried to think about within this area. A lot of folks are aggravated with the IRS. They were particularly aggravated with the IRS for requiring a code of ethics, requiring sort of board governance provisions. They were like, that's more state law. The interesting thing for me when I think about rules and standards, it's a heck of a lot easier to adopt a rule along those lines where we can see visible things that they do to give us indicators that they're a good organization. So I actually like thinking to look into those types of areas to develop rules. They're no panacea to solve the problem, but I think a lot of the folks that were complaining about it worry a lot about the oversight of charitable organizations. And I think it's one of the more useful tools that the IRS has as a bully pulpit to encourage these organizations. I mean, I can't tell you the number of organizations that I go out to, and I don't know if you see this in the clinic, but that are just poorly run. And it's not because you have bad individuals involved in it, but it'll be a whole family that's running this thing, and then they've hired all their family members, and now all of a sudden we have serious duty of loyalty problems in a small organization. It might have 500,000 in revenue, but they're putting themselves at substantial risk of both IRS problems. It's unlikely that these things will happen, but they're not running their organizations well, and I think implementing those types of things could be beneficial in a rule sense. I don't know if I fully answered the question, but I've tried to give some thought to that. I think it's a prime place to think about using rules that are simple checkboxes to allow the IRS to do a simpler job. Even though it might be outside the scope, technically, it answers some of the questions that we want nonprofit organizations to do to operate in a better way.
Bill, you've had the unique perspective of approaching this both from in an academic setting, but also as a regulator. When we think about replacing standards with rules, did you have any pet peeves or sort of instances where as a regulator, the application of a standard seemed particularly difficult, and you thought, boy, if we could replace this with a hard and fast rule, we'd be able to deal with some of our resource issues, or maybe it would be a better way of regulating this activity. Can you point to a couple of examples of places where you would insert rules?
So I've tried to give some thought in it, but I'll give an admission against interest to start. When I started with the IRS, the Pension Protection Act was enacted, and Paul will know about these organizations. There are groups called supporting organizations, and I don't know how many are familiar with this. It's very inside baseball within the charitable world, highly complex. The regulations have been described as some of the most ridiculously complex regulations that are out there. Has lots of standards in it as well as some rules. And when I got the project to try and write the regulations for this, it was like, I'm going to write this in very simple, easy to understand terms, and I failed miserably. So I think an area that it can be done, and it got wildly criticized, but the IRS, before Congress stepped in, they implemented a draft notice of proposed rulemaking on 501c4s engaged in political activities. And they said things like, no voting guides. If you do voting guide, it's political and we're not going to take it. I think it was not within the justice realm, because there's certainly some people that put out some fabulous voting guides. The League of Women Voters, great job, and it's a useful resource. But there's a whole bunch of folks that abuse that system. I think that's a great place in the political realm to implement rules that will protect the IRS, let people know what those things are, and just make clean calls, and we have to live with it once that thing is done. Now, there are some that don't think that those rules should even be there, that these organizations should be able to speak as they like. But I think while the standard is there that they can't intervene, I think it would be super helpful to develop very clean, clear rules and keep the IRS out of this thing and not worry about the tax exemption aspects of it so much. So that's the area that I would say I think they're real easy. It's not easy because it's highly political and difficult to do, but it would be the type of move that I'd like to see happen.
How much, we talk about these problems of the perceptions of what the IRS is doing, and also some of these concerns about the vagueness of the guidance that goes out. I'm wondering how much of these problems are of the IRS making as a result of the secrecy that is attached to taxpayer data, but seems to then spread to everything else that the agency does, and the lack of disclosure on all sorts of things.
Yeah, I think so answer this in a somewhat a roundabout way, although not. When the Tea Party matter happened, the IRS can't talk about any of the cases. In the IRS's perspective, it's gotten rebuked by some courts regarding its interpretation of return information. But as I told a reporter, one of your fastest ways to the crowbar Hilton in the IRS is to disclose taxpayer data. And so I think that's a problem of the law that I think most of us are willing, we're willing to accept because nobody wants their tax data to be disclosed. Interestingly, coming back to the original enactment, when they enacted the original corporate tax, corporate returns were disclosed for 1 year. Major public corporations. There was a sense that the IRS might fulfill a sort of SEC-type corporate regulator role. That was so despised, there was major lobbying, and it was gone the next year. And I think we have come to a point where we accept it as something, and that creates enormous problems because the IRS doesn't talk. It doesn't disclose things. It tries to keep as tight as it can. So when I talk in front of the public, one of the main reasons I liked leaving the IRS and going into academia was because I had a voice. When I spoke for the IRS, I had to be extremely caged. And I would always, I'm pretty good at feeling people's pain. And I would feel folks' pain when I'd go out there. I understand what you're talking about. We're really concerned about that issue. And I can't explain where we are on that issue. And that creates part of the difficulty. But I don't think that's one we can really fix. I think the IRS has to defend that data very closely, and it probably has to use a rule in a sense that pushes it over into an over-inclusive kind of realm where it's not having those open, honest discussions with individuals that would be ideally there. But I don't know if that's one we can fix. I don't know if that answers the question. It's a good question.
I think we're going to have to leave it there. We're at 5:30. Phil,
Thank you.
small token of our appreciation here on behalf of the law school. And absolutely. And we've got food outside. So please join us. I think CLE forms get handed in at the table outside too, if that's what you're seeking. Thank you for coming. Good job. Thanks so much, Phil.